Welcome to Cardamone Law University, translating the Pennsylvania Workers' Compensation Act into plain English for injured workers. It's Mike Cardamone here. Today I wanted to go over the vocational process in workers' compensation in Pennsylvania. There's a concept called a labor market survey or an earning power assessment. And what this means is when an injured worker is receiving workers' comp wage loss benefits, and the employer where the injury occurred cannot accommodate the injured worker's work-related restrictions medically, then the insurance company will hire a vocational expert to conduct an initial interview. And that process is the beginning of the labor market survey, where the end goal for the insurance company is to file a petition to reduce your workers' comp checks by claiming that you have an earning power based on your physical restrictions from the work injury and your vocational abilities. They start this process with a vocational interview, and this is a huge turning point in a case. We always say this, but it's true. If you don't have an attorney, make sure you call us, because this is the beginning of a process where they're trying to take food off of your table. Our number is 215-206-9068. We will attend the initial vocational interview with our clients to make sure they're prepared, they know what kind of questions will be asked, and to make sure there's no overreaching by the vocational assessment expert. Once they conduct this interview, which generally takes 45 minutes to an hour, the expert will try to find jobs that fit within the injured worker's restrictions, again, physically and vocationally. And then we'll receive a report 1 to 2 to 3 months later outlining which jobs the vocational expert found. And normally it'll list the contact information as well, the hours, the rate of pay, the description of the job, etc. The vocational expert will normally have these jobs reviewed by the independent medical doctor. Why? Because the independent medical doctor is more likely to have less restrictions on you. And then they'll send the job descriptions to that medical expert, and the doctor will normally sign off and approve them. And then that gives them the right to file their petition to either modify or suspend your workers' comp checks. It'll get set up for a hearing, and at the first hearing, we'll have to make a showing that we have some defense to their claim in order to keep the checks going throughout the litigation. It's called supersedious. And again, if you don't have an attorney, you really want to make sure you get a certified workers' comp attorney like us to help you out. There's no cash outlay or anything like that. We only get paid if there's a court order, which means we have to be successful in your case in some regard. In any event, one of the really important things here that the vocational experts will forget, or the insurance company, I should say, is sending out what's called a notice of ability to return to work. That's a document required by the Pennsylvania Workers' Comp Act whenever the insurance company receives evidence that a doctor believes you can work in some kind of capacity. And a lot of times that's a document that's not sent, and that can give us a technical argument to your benefit. Another thing is the insurance company should secure an affidavit from your employer where you were injured, confirming that they cannot accommodate your restrictions. That's really a condition precedent to beginning the labor market survey process. Because if they can accommodate, then normally you'll see a job offer saying, hey, come on back to work. We can accommodate your restrictions, and here's the start date and the description of the job, etc. Now remember, there can be a disagreement between the doctors. Your doctor might say no work at all, or alternatively, your doctor might say you can work, but you need the following restrictions: no lifting over 10 pounds or sit and stand as needed, etc. Conversely, the independent medical doctor might say you can lift anything, over 20 pounds. So they might have less restrictions on you. So the insurance company is more likely to send that doctor's restrictions, the independent medical doctor, to the vocational expert because they'll be more likely to find jobs with less restrictions, of course. So we attack these cases usually on two levels, other than some of the smaller technicalities. One is medically, because our doctors generally will give more restrictions than the independent medical doctor, although not always. Sometimes they agree with each other. And even in rare cases, sometimes the treating doctor has less restrictions than the independent doctor. But also we attack these claims on a vocational basis. What that means is we'll sometimes hire a vocational expert to review their expert's report. And a lot of times our expert will find a lot of deficiencies in their analysis. Here's one example. Maybe their expert says one of the jobs can accommodate the restrictions of no lifting over 20 pounds or 10 pounds. Our expert might call up that job and talk to a representative, or even show up and view the job, him or herself, and find out that they have to take out trash every day in that position, and the trash could weigh up to 50 pounds. Well, that could be a way to attack that particular job. So a lot of times our vocational expert is successful in finding out that the job description isn't always accurate, and that can really help us out. So make sure you call us if you get any document stating that there's a vocational expert involved in your case. They're trying to take food off your table, literally, and that's their job. That's the role of workers' comp. And it's nothing unethical or illegal. They're entitled to, under the Act, try to establish an alternative earning power. And we're also entitled to fight back and with our own experts, either medical and or vocational. Once it's in court, a lot of these cases will settle. They'll be set up for mediation, and a lot of times we're able to resolve these cases before they go to a final decision on the merits by the judge. But you want to make sure you have an attorney to review your case and to tell you how to fight back, which doctor we should utilize, and whether we need a vocational expert involved. There's a lot more material to go over with respect to this vocational assessment or labor market survey, but we just wanted to give you an overview today. If you have any questions, always feel free to call us. It's 215-206-9068, or you can email Attorney Cardamone directly. It's Michael, Michael, at cardamonelaw.com. That's Michael at cardamonelaw.com. Signing off for now, thank you, and we'll talk to you again soon from Cardamone Law University.